There sometimes seems to be some sort of confusion as to, especially for a first-time home purchaser of a property, as to why they are dealing with two different sets of attorneys. So this happens in the case where the purchaser, new first-time home buyer, has obtained finance in order for them to afford the purchase consideration of the property. So they would have gone to, for example, either their own bank to obtain approval for a mortgage bond, or sometimes they can go to what's called a mortgage originator. A mortgage originator is mandated on behalf of the purchaser to approach all the financial institutions in South Africa in order to obtain the best rate or the amount of the bond that they need to register. So the mortgage originator would apply to all the various financial institutions, and once a bank has approved a purchaser's finance, then that particular bank will instruct an attorney to attend to the registration of the mortgage bond on behalf of the bank. So that is what is called the bond attorney. The transferring attorney is appointed by the seller to attend to the registration of transfer. Coupled in this mix, you can get various other attorneys or linked parties into the transaction. It sometimes becomes a little bit complicated where the seller themselves has also sold their property, or a purchaser has also sold their property, and then at times we have to collaborate with 3 or 4 different sets of attorneys into the deeds office. We then have a question as to, a purchaser would say to us, why does he need to pay 2 sets of fees, and when are these fees actually payable? So although the seller appoints the conveyancer to attend to the registration of transfer of ownership, the purchaser is responsible for paying the transfer registration costs. The purchaser has a bond that is going to be registered on the property. The purchaser is also obliged to pay bond registration costs. Both of these sets of fees will be payable to the respective conveyancers that have been appointed in respect of each instruction, most likely on lodgement of the transaction in the deeds office, and definitely before registration of transfer and registration of the bond actually occurs. There are several documents or clearances that we need to obtain in order for us to effect registration of transfer of ownership. These would be regarded as a rates clearance certificate. This is an obligation on the seller to pay all the rates that are due on the property at the time of transfer. Various municipalities work in various different ways. In terms of the City of Cape Town, the seller is actually required to pay advance collections in order to obtain the rates clearance certificate. This is a task that the conveyancers, Strauss Daily attorneys, will do on behalf of the parties. So we have various integrated software programs that conveyancers integrate with the City of Cape Town's systems in order to obtain the rates clearance certificate. And once paid, we will then get a rates clearance certificate. Another type of certificate that we are required to obtain in order to effect registration of transfer of ownership is a clearance from the tax office, or SARS. Depending on the type of transaction as to whether it will be a transfer duty related transaction or a vatable transaction, this will be recorded in the sale agreement, will be dependent on whether we obtain a transfer duty receipt or a VAT clearance from the receiver of revenue. The clearance that we obtain from the receiver of revenue and the clearance that we obtain from the municipality are both required to be presented at the deeds office when we lodge the documentation at the deeds office. The process in the deeds office is, once the transaction is lodged, is for the deeds to be scanned, certain data checks done, and then there are 3 levels of examination that the deeds need to pass through before they come up for what is called registration of transfer. A common question that we have from clients is, how long can I expect my transaction to take? So a time period on this is largely going to depend on if the parties have agreed to a particular date of registration of transfer or a particular date of occupation of the property. So when a seller and a purchaser sign a contract of sale for a purchaser to acquire a property, there will be a provision in the sale agreement as to the date of registration of transfer. The conveyancers are then required to, as far as possible, work towards registering the transfer of ownership either on that date, if that is possible, or within a short, reasonable time thereafter. On the date of registration of transfer, the conveyancer that is appointed in respect of the transfer and the conveyancer, if applicable, in respect of the bond, they would link up in the deeds office and sign off or execute the deeds in order to effect registration.